All right, let's just jump right in. Welcome to today's explainer. We're going to unpack a super crucial aspect of business law that literally anyone who sells anything needs to know. We're talking about the unpaid seller, and more importantly, your rights when a deal goes south. If you've ever handed over a product and then found yourself, endlessly chasing down the money, well, this is exactly for you. We're going to translate all that Sale of Goods Act legal jargon into actionable, real-world knowledge.
So picture this, you've just closed an amazing deal. You handed over the goods to the buyer, they handed you a check, everyone smiled, shook hands, and you walked away feeling great. But a few days later, you get that dreaded ping from your back. The check bounced. Insufficient funds. Man, it's an incredibly frustrating but unfortunately very relatable everyday business problem. Suddenly you're out of your product and you have absolutely zero money to show for it. So what exactly are your legal options right now? Do you just have to sit there, cross your fingers, and hope they eventually pay? No way, absolutely not. The law actually gives you some really specific, powerful tools to handle this, and that's exactly what we're going to break down today.
Here is our quick roadmap for this explainer. First, we'll clearly define who actually qualifies as an unpaid seller. Then, we'll look at your rights against the physical goods themselves, and finally, we'll wrap up with your rights directly against the buyer.
Okay, moving right along to part 1. Who exactly is an unpaid seller?
I know, it sounds pretty obvious, right? But in legal terms, precision is everything. And what's really fascinating here is just how broad this definition actually is under Section 45 of the law. An unpaid seller isn't just someone who got completely stiffed and received zero money. It's a person who has sold goods but hasn't received the full price. Plus, and this connects right back to that opening scenario, if you accepted a check, a bill of exchange, or any negotiable instrument, and that instrument has bounced or been dishonored, boom, you instantly become an unpaid seller. You don't have to wait for a judge to declare it. The bounced check itself automatically triggers your new legal status.
To show you just how strict this rule is, let's look at a quick example. Say Vani sells her laptop to Bhavna for 30,000 rupees. Bhavna pays 29,999 rupees, but for whatever reason fails to pay that final single solitary 1 rupee. Legally speaking, Vani is still classified as an unpaid seller. Being short even a tiny fraction of the agreed price triggers these strict legal definitions and grants the seller all their associated rights. It's not about being mostly paid, it's about being fully paid. Period.
So, once you realize you're officially an unpaid seller, what can you actually do? Well, the law basically splits your legal superpowers into 2 distinct buckets. On one side, we have your rights against the goods, legally known as a right in rem, basically actions you can take regarding the physical items you sold. And on the other side, we have rights against the buyer, or right in personam. These are the direct legal actions you take against the actual person or company who bailed on the payment.
Let's dive into that first bucket. Part 2. Your rights against the goods.
All right, let's explore the control you have over the physical items themselves. The most fundamental right you have here is the right of lien, which is covered under Section 47. To translate lien into everyday language, it's basically the right to hold the item hostage. Think of it like a mechanic refusing to hand back your car keys until you pay the repair bill. If you still have physical possession of the goods, you can just outright refuse to hand them over until the full payment is made. Now, this kicks in during 3 specific situations. First, if you sold the goods without any credit terms. Second, if you sold them on credit but that credit period has officially expired. Or third, if the buyer goes bankrupt or officially becomes insolvent. If any of those are true and the stuff is still in your hands, keep it.
But what if the goods have already left your warehouse? Well, that brings us to stoppage in transit under Section 50. This is almost like a movie scene. Check out this timeline. Step 1, the goods leave your possession and are handed over to an independent carrier, like a shipping company or a trucker. Step 2, while those goods are literally on the move on the highway, you find out the buyer has become legally insolvent. They went bankrupt. Step 3, you have the incredible right to contact that independent carrier and stop the delivery mid-transit. You can instruct them to hold the goods and just not deliver them to the bankrupt buyer. It's fantastic protection, but remember, the absolutely crucial trigger here is that the buyer must be legally insolvent while the goods are still moving.
Okay, so you stop the truck, you have the goods back, but you still really need your money. Enter Section 54, the right of resale. The rules here depend heavily on whether you communicate with that defaulting buyer. Quick caveat here, if the goods are perishable, like fresh fruit or something, you can resell them immediately without telling anyone. But for non-perishable goods, the rules change.
If you give the original buyer prior notice that you're going to resell, you are fully legally protected. If you resell it and take a loss, you can actually claim that deficit from the original buyer. And if you somehow sell it for a profit, a surplus, you get to keep it. But if you resell without giving notice, the tables turn completely. You cannot claim any losses from the original buyer, and if you make a surplus, you're legally obligated to give that extra money to the buyer who defaulted on you. So giving notice is your absolute best friend here.
And finally, wrapping up our rights against the goods, we have a super straightforward one: withholding of delivery. This simply applies to situations where the official legal ownership, the actual property in the goods, hasn't even transferred to the buyer yet. In this scenario, you don't even need to worry about liens or stopping transit. You can simply say nope and withhold the delivery altogether.
Now, let's shift gears to part 3, your rights directly against the buyer.
So, what if the goods are long gone or you used your right of resale but still took a massive loss? These are your rights in personam, your options to take them to civil court. Let's run through them real quick. First up, Section 55, suit for price. If ownership has legally passed to the buyer and they haven't paid, you file a direct case to recover that exact agreed-upon price. Super simple. Second, Section 56, suit for damages. If the buyer wrongfully refuses to even accept the goods and pay for them, and that causes you a loss, you sue for those specific damages. Third, Section 60, repudiation of contract. If the buyer tells you before the due date that they aren't going to pay, which is called an anticipatory breach, you can officially cancel or repudiate the entire contract right then and there. And fourth, Section 61, suit for interest. You don't just have to settle for the base price. If it was in your agreement or if the court grants it, you can claim interest on that delayed payment to help make yourself whole.
So as you can see, the law actually provides an incredibly robust safety net. From holding goods hostage, to stopping them on the highway, to dragging a defaulting buyer into civil court for the price, damages, and even interest. But here's the catch. All of this hinges on having clear agreements and understanding exactly when to pull these legal levers, which leaves us with a critical question for you to take away from this explainer today. Look closely at how you do business. Are your sales contracts clearly written to maximize and protect these really powerful rights of the unpaid seller? Because knowing your rights is the absolute first step to ensuring you never walk away empty-handed. Keep learning, keep those contracts tight, and I'll catch you in the next one.